Good evening, honorable guest and respected member of audience. It is both an honor and a privilege to welcome you all to today's interactive discussion on victim compensation in criminal justice system. First of all, I would like to extend my gratitude to Honorable Chief Justice and Chairperson of ILI State Unit and Member of Bar Council of India, Honorable Suvir Sidhu ji, for extending the immense support to organize this important event. As we all know, victim compensation is a crucial yet often overlooked aspect of criminal justice system. In our criminal justice system, we are more focused on punishing the offender. But a true justice is incomplete until or unless the victim who has suffered due to the crime has been adequately compensated for his sufferings. As everybody know that prevention of a crime, it is duty of the state to prevent any crime from happening. And if state fails in its duties and any crime happen, so state should shoulder the responsibility to compensate the person who has suffered due to its dereliction in duty. So there are, despite legal provisions such as 357 and 357A and various victim compensation schemes, but victims practically face many challenges such as bureaucratic hurdles, inconsistent policies across the pan-India, and lack of awareness among the victims. So I have my personal experience in it. I have litigated in victim compensation cases. In the cases, I have first-hand witness of the suffering of the victim, that how they face such difficulties in order to secure their rightful compensation. It is a privilege that I have contributed in a landmark judgment passed by Honorable Mr. Justice Vinod S. Bhardwaj ji, in which he founded the right to get compensation for a category of victims, which are the victims of road accident hit and run cases. And in these category of witness earlier do not get any compensation, or they get a meager amount in the name of compensation. After the judgment of Honorable Mr. Justice Bhardwaj Sahab, they had the right to file claim application before the DLSA. So what we can say, that it is only due to the judicial eminence of justices like Justice Bhardwaj, Justice Deepak Gupta ji, that this victim compensation has taken its present shape. So we can now today we will discuss on the various aspects surrounding the victim compensation, such as legal provisions, such as judicial interpretations, and the challenges with the victim faces, and the potential reform which can take place to make it more efficient and effective. So without waiting any further, it is my great honor to introduce the chairperson of the panel, Honorable Mr. Justice Deepak Gupta ji, who has served in the lower and the higher judiciary. So by his extensive experience and extensive expertise in the judiciary, he will able to deepen our understanding on the present topic. So the topic I would like to invite our chairperson of the panel, Honorable Mr. Justice Deepak Gupta ji, to share his valuable insight on the evolution of victim compensation in Indian law, judicial interpretation, and key judgments.
Thank you very much for providing this opportunity. As Mr. Uday told you, and everybody knows, that our criminal justice system since the beginning that has been focusing upon offenders only, and least attention is given to the victims. It is despite the provisions contained in the form of Section 357 CRPC. Later on, 2009, Section 357A was introduced, but that was also after the judicial intervention. It is the judicial intervention that Honorable Supreme Court, in Rudil Shah's case probably, in in Rudul Shah's case, 1983, that they interpreted Article 21 of the Constitution to ensure that compensation is not merely an act of state generosity, but a constitutional obligation. So, Section 357, as it contained originally in the CRPC, and now it is a 396 probably in the BNSS, it has its own limitations, because compensation thereunder can be provided only after recording the conviction. And that too, if appeal is filed, then no compensation is payable. So these inadequacies were addressed by the Supreme Court, and it directed the government to frame necessary schemes. Section 357A was introduced, and under the schemes framed by these various state governments under 357A, now the compensation is payable not only after the conviction, but even when the FIR itself is registered. And if the victim is identified and even the accused is not identified, even then the compensation can be granted. But as Mr. Uday told, there are still the limitations, there are still various hurdles, various obstacles, bureaucratic hurdles, then inadequacy of funds provided by the various governments from time to time. These are the hurdles, and then most importantly, there is lack of awareness. Although legal service authorities all over Punjab, Haryana, I have also been member secretary of legal service authority Haryana for a long time of more than 3 years, and lack of awareness, that is the biggest hurdle. So it was our utmost endeavor through legal awareness camps and legal aid clinics, etc., that the victims, they are made aware of these their rights, that they can claim compensation. And I remember we had collected various schemes from the union government as well as the Haryana government, and we collected various forms, and we used to distribute them in jails and also legal awareness camps, so that people can be told that how to fill up the forms. The advocates, the advocates on our panel, they were empowered for that fact. They were made aware of this fact. First of all, they were provided training to that effect, that how to make the people aware, and that resulted, that yielded good result. And now I am not aware about the latest position, but I recall it very well, that with the passage of time, the government increased the fundings. The Haryana government increased the fundings for this victim compensation, and of late, various funds, you can say, compensations are being provided to the victims in various cases. But even in that aspect, as of now, the compensation is provided only in some limited cases. For example, physical assault, rape victims, acid attacks, etc. Its scope is liable to be, in my view, it's liable to be increased, because victims, not necessarily that's a victim of assault, it may be a victim of fraud, it may be victim of, you can say, trauma, physical trauma, mental trauma, it may be, you can say, theft, robbery, they are also the victims. And I think at some times, even the accused may be the victim. Let us assume that it's not assuming, practically we see it's every time that numerous acquittals take place. Acquittals may be for various reasons. If it is for lack of evidence, it is for reason that witnesses have turned hostile. This is a different issue. But if the ultimately court finds that in fact he was falsely implicated and he was convicted by the Sessions Court, conviction upheld by the High Court, but ultimately acquitted by the Supreme Court, by the time his acquittal is recorded by the highest court or by the High Court, he stays in jail maybe for 10 years, more than that. What is the fault? Ultimately, if the court holds that there was no evidence, complete no evidence, he was falsely implicated, maybe at the instance of the police or maybe at the instance of the complainant, what was the fault of the accused? So in these circumstances, I feel that accused is also the victim. And in future, we must see that such kind of accused, they should also be compensated. As of now, as far as I understand, it's only section 358 or 359 which provides for some sort of compensation that is very, very inadequate. 358 is hardly 100 rupees probably. 100 rupees just nothing. 100 rupees. Hanji?
Now it has been enhanced to 1,000.
1,000, sir. What is the 1,000? 1,000.
100 से 1000 can exclude.
1000, this is just a mockery, I'll say. So we have to look towards these things also, that adequate compensation is provided even to such kind of victims. Then witnesses who have to take round and round and rounds of the courts, whose statements are not recorded. They will be paid the meager compensation only for expenses for attending the courts, nothing else. For diet money also, my practical experience is for paltry sum of rupees 100 or 200 rupees. They have to take the, you can see they have to go to the desk of the Elmod and then not, and whole days is consumed, and in the last they will say better not to take the amount. They have to take the leave from their employee. No employer is going to compensate them for the loss. So these are various aspects that it's not the victim of, you can say, crime only. We have to see victim of crime includes so many things. Accused may be the victim, then the witnesses may be victim, and then what about family members? What about family members? Family members of the accused as well as the family member of the victim. I think they are the real victims sometimes. Murder is committed, accused, the earning member, he is sent to jail. The real sufferer, he will get maybe the meals in the jail. What about the family members who were totally dependent on them? Well, if we see it in the larger perspective, they become also the victims. So all these has to be included in future schemes. For as of now, it's very limited. It is limited only to the victims, victims of crimes only, and that of only of assault, rape, acid attacks, etc. So I think this is the way forward, and of course we have to remove all the inadequacies that this has been pointed out, Mr. Uday Singh, whether this is bureaucratic hustle, that is inadequate funds, and the making the people more and more aware. This is what I wanted to share with you. Thank you.
Thank you. Thank you, Honorable Mr. Justice. As we can summarize, the Honorable Mr. Justice highlighted the foundation role of Article 21 in shaping the victim compensation in the form of 357A, and it is only due to the judicial intervention, judicial interpretation, that the approach of the punitive approach shifted to the rehabilitative approach, and thereby creating a victim-centered approach. So despite this judicial progression, the victim face many challenges in receiving the timely compensation, consistency of the compensation amount across the state. So to address this critical issue, I would like to invite our next panelist, who needs no introduction, a former Advocate General of Punjab and designated senior advocate, Shri APS Deol ji. I would like to invite you to share your valuable insight on the topic, ensuring timely compensation for victims and standardization of compensation across India.
Thank you, Mr. Uday, for giving me an opportunity to be amongst you. Had the advantage of hearing the valuable views expressed by my Lord Justice Deepak Gupta, who has the experience and the expertise having dealt with the Legal Services Authority and being chairman of the Haryana Services Authority. There are certain viewpoints which he has placed before us, which are very valuable. And just to contribute a little more from my side as my experiences as a criminal lawyer, I would share that we have come a long way in the Victim Compensation Act, compensation scheme. Earlier, there was no such, the only what was provided in the IPC was fine. Like Mr. Deepak Gupta has rightly said, that the main thrust of the criminal justice system was to punish the offender and not compensate the victim, because there was no such provision. So 357A for the first time was introduced. This was by way of which compensation was to be provided. Earlier, there was no such provision. So that was the first turning point in our judicial system, that some compensation, issue of compensation, by following the foreign judgments, mostly of UK, where the victim compensation schemes were much ahead and they were introduced much earlier. So we came out with 357A in 2009. and 357B and 357C in 2013. So that all started the whole evolution of the compensation, victim compensation scheme in our country. Then Nirbhaya and cases like exploitation of the not only female, sometimes male gender also, exploitation in different ways, sexually as well as physically. So that exploitation in mass number of cases came to fore, where it was thought in the case of first time the Honorable Supreme Court took cognizance in Nipun Saxena versus Union of India in the year 2012 in writ petition took cognizance, and then it was where the National Legal Services Authority took its birth. The NALSA, which we now know, took its birth on the basis of this judgment rendered in Nipun Saxena. Direction was issued to the central government to constitute this authority for the victims of trafficking and commercial sexual exploitation. That was, it was called the Victim of Trafficking and Commercial Sexual Exploitation Scheme 2015. So it gave much wider horizon to the victim compensation. So they identified more kind of victims, like my lord has rightly pointed, that we were very limited to certain offences only. Then it came, this opened vistas for compensation to other sectors, which we were not really had delved into earlier. So with that, the Supreme Court, like is all, most of these schemes are based on they call it not the legislative centric law, but the judge centric law. So this is one of the evolution of a justice centric law that took the shape of the Legal Services Authorities Act 1987. This was the beginning, where they said that we must formulate this Legal Services Authority Act 87 under some statute where to give sanctity to these schemes. We can't have these schemes on our own. There has to be some sanctity. So this was the beginning. And then it was not only for the purpose, this victim trafficking commercial sexual exploitation scheme, it was for rehabilitation of women of all age groups, and voluntary sex workers are marginalized groups. In the Northeast, you will experience, if you have traveled, there are many different kind of exploitations, and they are marginalized people. They don't even know the courts. They don't have means to go courts. They have not seen the courts and the working, because the distance and because of the far-flung area, because of the situation in which they are put in. So all these things led to this integration of victims into society. So once you get them out of that situation, then how to integrate them into society. This is all victim compensation. Compensation not monetarily, but to rehabilitate a victim out of that issue. So it had taken shape in that form. Then it was after that this NALSA was formed. Then they identified more avenues, and then it started how to implement that. Schemes were formed. Schemes are generally formed, but it is very difficult to implement. Implementation needs so many workers. What kind of workers? Whether there were no enough recognized the public servants in that the social compensation, this schemes, who would implement and identify those victims, and then who are genuine. There are always cases of exploiting the system. So all these things started. Then they thought of engaging in the schools by the name of Sarva Shiksha Abhiyan. This was one scheme which the union government started. Then social welfare departments were also associated. Then paralegal volunteers, social welfare departments, then legal services clinics to ensure free legal aid and protection. NGOs are playing a very important role in this. NGOs, where the NGOs are prominently working in some places in the country where they are adding and contributing to this victim compensation scheme. Then with the new now legislation having taken form, after the 357 ABC, now they are replaced by 396 section 397. And I was just going through which my Lord Justice Deepak Gupta has just referred. 396(3) is that provision which says, if the trial court at the conclusion of the trial is satisfied that the compensation awarded under 395 is not adequate for such rehabilitation, or where the case ends in acquittal or discharge and the victim has to be rehabilitated, it may make recommendation for the compensation. So this is a path-breaking provision that even if the accused is acquitted or discharged, still the victim who has suffered, he should be compensated. So this is something new in our the new code which has been introduced, which was earlier in 357(3), but not in so many words. So this is one. And then equally important is that the accused should be compensated, the witness compensation to the person groundlessly arrested. So we are just falling short. Acquittal, compensation for acquittal there's no provision. Only for groundless arrest, which is very little at a stage that whosoever police officer groundlessly arrests a person, he can be compensated, and compensation not exceeding 1,000 rupees. So we are just at a very preliminary stage, and where the person, like my Lord referred, that you go up from one hierarchy of court, from district court to high court to Supreme Court, and then get acquittal after 10 years, there is no provision for compensation. So all this needs to be addressed equally, keeping the balance. But since we are now dealing with the victim part, so as far as that is concerned, Mr. Uday said that since you are a lawyer, you must refer to some case law. So just one judgment I could get hold of was a case which I had appeared before a division bench. This was Nishant Singh versus State of Punjab, decided on 31st August 2018, before my bench headed by Justice A.B. Chaudhary. There, although I was for the accused, not Nishant Singh, but the other, they were acquitted, but Nishant Singh was convicted. The girl, they are a consenting party from Faridkot. They both had eloped to Goa. But while taking away the girl, he had used force. He had fired and all from the custody of his lawful guardian, parents, and took the girl from here. Though later with consent, they travelled here, stayed in Chandigarh, then travelled by air to Goa, and they stayed there after they traced out 15-20 days. It was a very infamous case. There, while holding him guilty, the trial court held him guilty, and in the appeal, my Lord Justice A.B. Chaudhary's bench awarded a path-breaking amount of compensation. I'll just read the last part of the order. Nishant Singh and Navjot Kaur, that is his mother, shall pay a total compensation in the sum of 90 lakh, 50 lakh to the prosecutor ex, 20 lakh each to the complainant Ashwini and his wife Seema. They were who were trying to stop this act of taking away the girl, minor. So 90 lakh was awarded, and the collector of the district Faridkot is directed to attach the agriculture as well as urban property of both Nishant Singh and his mother forthwith, proceed to recover from the sale proceeds thereof from the amount of compensation of 90 lakh as aforesaid, and distribute the same as stated in the present order. So this was something new to us when we saw this, and that also coming in the appeal filed by the victim. Normally, in a revision filed by the victim, much care is not taken. But here, my lords were sensitive to this issue. And although this was half the amount was stayed by the Supreme Court later, but this was one judgment where a huge amount was compensation and immediate succor. 90 lakh to be recovered within 10 weeks to be paid by way of land revenue from his agricultural land. So, but this is not provided in the this system of the scheme of this compensation which the state governments have framed. Now, as far as the uniformity in the grant of compensation amount is concerned, I just got hold of Haryana notification of 2020 where a schedule is made. The schedule says that the loss of life would be 10 lakhs, upper limit 5 to 10 lakhs. That is the maximum. That is, it comes down in a case of gang rape also to 10 lakh, but 10 lakh is the maximum. And then in case the woman victim of assault is a acid attack is covered with one or more categories, then it will be entitled to combined value of the compensation. So there is a categorization for loss of limb percentage. If it is 80%, 40%, it comes to 2 lakh, 3 lakh. So talking about the uniformity. So this is the pattern followed. More or less, same pattern is followed in Delhi. Delhi was earlier. This came in 2020. The Delhi Union Territory also has a chart, the schedule. The payment is as per more or less on the same lines. This is of the year 2017, this 2018, Delhi Victim Compensation Scheme. So this is 18, Haryana is 20, and the Punjab is 17. So this also more or less on the same line, but with one caveat that where the age is less than 14, then it will be double the amount of compensation. So that is one caveat in the case of this schedule. So the more or less it remains the same. So there is uniformity, but Punjab is a little less. The amount as far as Punjab is concerned in the schedule, they have maximum compensation under the schedule. They also have a schedule. It is also called the same, the scheme is the same, but the Victim Compensation Scheme 2017. So maybe they need to amend it or further enhance the amount. Here for the acid attack is 3 lakh and death due to acid attack is 5 lakh. So maximum is 5 lakh, and in case of rape and victim it's 3 lakh. But otherwise the more or less it's on the same lines. So that is about the, I think because of the funding. Now where does the funding come? So the sources of funding for the compensation amount to be disbursed is, one is by the government. It keeps some funding in the budget. Some is from under the Companies Act, which I just read. I didn't have any clue. 135 section of the Companies Act also has a provision where the company goes into the court, asks the company to put some amount for the purpose of legal, this victim compensation. Corporate. And also, in every day we see in the courts, our courts are very liberal. They always, first choice is the Legal Services Authority. You deposit this much amount. So this is one big source which is coming forth, which we see every day for the corpus to raise for the victim compensation amount. So others are the NGOs, some are contributing, some are the charitable trusts, they are contributing also. And this is how this corpus is getting more, funding. So this is all for the time being. Little I could contribute before you, and thank you for.
For providing us the comprehensive analysis of the various challenges and the standardization and how we can do away this inconsistency in the victim compensation. So it can be done by a way of amendment in the various victim compensation schemes of various states, or center should frame guideline to create a center victim compensation scheme, so that the amount across the pan India will be same. So now, as we continue to explore the more practical side of the victim compensation in the criminal justice system, I would like to invite our next panelist, Mr. Deepak Sabharwal, Additional Advocate General Haryana and Special Public Prosecutor CBI, to provide us valuable insight. And his expertise I have personally seen in a farmer protest case. It took me 8 long months to get an order from Honorable High Court to get Shambhu border open. Or it is only because of the able expertise of Additional Advocate General Mr. Deepak Sabharwal ji will provide us in his valuable insight on procedural and implementation barrier that hinder the swift and effective disbursement of the compensation.
Thank you, Uday, and I am thankful for the organizers for calling. Already Honorable Justice Deepak Gupta ji, Mr. Deol Senior Counsel have already enlightened us about the victim compensation part. So this concept of victim came after 61 years of independence in our country for the first time on 31st December 2009. The word victim is added in the CRPC. So it was added in two sections, 1372, for putting the victims on the same pedestal as the state. Because prior to this, the victim was not having a right to appeal. They were totally out of picture. So this amendment came, luckily, after 61 years of independence. And then regarding the compensation part, section 357, 357A is added also on the same day, 31st December 2009. So the first full bench which I luckily argued before the full bench headed by Honorable Justice Suryakant in Tata Steel matter, it continued for about 55 days, continuously from 2 to 4 p.m. And I was representing the Tata Steel in that case. So I am giving this background because then a question arose that whether complainant is also a victim or not. So it's your lordship in full bench have given a wider meaning to the definition of victim, that who is victim. And it has been given a very wider meaning that whoso all are included in the victim. Because prior to this amendment, the victim has to depend upon the state. That if suppose the person is acquitted and the victim has to see that whether the district magistrate who is having power under the CRPC, it is on his whims and fancies that if he gives approval for filing appeal, it is filed, and that too based upon the opinion given by the public prosecutor who has contested the case. And if it is not done, the victim is helpless. So just to put the victim on the same pedestal as the state so that he has not to see that whether the DM is giving permission or not, they are put on the same pedestal and the victim is recognized that yes, victim has an equal right as the state has to prefer an appeal also. Now as regards the, even in the full bench, your lordship have, I must quote, in the Tata Steel judgment, your lordship have written very strongly, and I quote, "For long the criminal law had been viewed on a dimensional plane wherein the courts were required to adjudicate between the accused and the state. The victim, the de facto sufferer of a crime, had no participation in the adjudicatory process and was to sit outside the court as a mute spectator. The ethos of criminal justice dispensation to prevent and punish crime would superficially turn its back on the victim of such crime whose cries went unnoticed for centuries in the long corridors of the conventional apparatus." So this was a very first judgment in our country whereby a word victim was interpreted, that who is victim. Now as regards the compensation part is concerned, the first, because judicial, it is only because of judicial intervention we have come up with section 357A, now 396 BNSS. For the first time in 1983, a person in Rudal Shah case, my lord have also referred, the then Chief Justice of India, Justice Chandrachud, has imposed a cost of 30,000 in 1983 in Rudal Shah case that a person who is acquitted remain in jail for 14 years after acquittal. So that was the first case in 1983, followed by the case in 2019 by the then Chief Justice, Justice Gogoi, in Bilkis Bano case where a compensation of 50 lakh was awarded on the Gujarat government, and it was said that even the job be offered in this case in 2019. And then later on many cases came that what is the fate of a victim. And now even the Haryana has also launched a victim compensation portal on 9th November 23 that you can apply online for the compensation. It is on two accounts, that first, if the court orders the compensation, or the victim can apply it online or through manual mode before the District Legal Services Authority, State Legal Service Authority. And just to facilitate, the portal is launched in the state of Haryana on 9th November 23. So although it is late, but now it's done. What my suggestion would be that why should victim move an application? It's the duty of the state that once an FIR is registered and the victim is before the police, suo moto the application, the recommendation should be made there and then, that whatever interim maintenance or interim compensation is required to be paid to the victim at that point of time, because time is very crucial. Because if later, after 10 years, even a compensation, or we can say it is paid, it is of no use. So my suggestion would be that why application? It should be suo moto act. And Haryana policy is changed from 2016, then 2020 policy is now going on in part 1 and part 2. So the data also I have seen, the data is that 10,000 orders from the court and 10,000 applications directly. And the compensation paid in so far from April 24 to till December 25 in Haryana is around 10 crores. So there has to be uniformity is required, that there is a centralized scheme which is mandatory for all the states to follow, because all this victim compensation is because of the judicial intervention at every step. In one of the case which I argued, which was a murder reference, like just Mr. Deol has said, it was also a murder reference wherein a death sentence was upheld by the division bench headed by Justice A.B. Chaudhary. It was a minor victim. She was gang raped and then murdered and then cut into pieces. It was a case of Rohtak. The death sentence was upheld by the division bench of this court. I argued that case also for long 10 days, the murder reference. And in that also, your lordship awarded 50 lakh compensation, 25 lakh to the sister of the victim, and 25 lakhs to the state to be recovered as arrears of the land revenue. Because in the scheme also of every state, the maximum compensation which I could gather is 10 lakhs, which is too less in the society which we live. It's too less, 10 lakh. The court, it is only with the intervention of the court. So we have to increase the budget. Because NGOs are helping. On ground, the people are not aware. And suppose the orders are passed, then the appeal is filed, then revision. It's a long process. The very meaning of compensating a victim goes if it is delayed. Delay is to be seen, and it is to be made time bound, so that a victim in need is provided the help there and then, which is not upcoming till now. So this is to be done at every stage, that the victim is provided the compensation at the threshold. Because in the system which we are also a part, it's a only paper thing. A person applies, then it goes, then it's cleared, then certain formalities are there. The very purpose is defeated. And as regards the data which I have collected regarding the applications which have been received from the NALSA website, in Haryana, the applications received from the orders by the court were 534. The application received directly 112. The decided are 645 and 120 are pending. And about 19.5 crore compensation is paid from April 23 till March 24. And even the total applications pending in December 25, March 24, Pan India are 17,229. And the compensation awarded is, yes, more than 400 crores. So we are heading towards that, but still much more is needed so that these complications are not coming in the way of a victim who is already a victim, and we should do something immediately and without any these hurdles. And regarding the states are also giving budget, but to the less extent. So there is a centralized mechanism is needed whereby the limit is to be increased and the funding is to be given so that the victims are compensated at every level. So this would be my suggestion.
Thank you, sir. Thank you, sir. As our learned friend, the Additional Advocate General, through his address, we can summarize his address by only one quote, that by quoting the data of NLSA, that compensation delayed is compensation denied. So, and he has provided a clear picture of the procedural and the implementation barrier. I have kept the most important topic at point number 5. So I will come to the person who has unparalleled acumen, unparalleled legal acumen at later stage. And I would like to invite my next panelist, a young advocate, Harnoor Sidhu, to share his insights on the topic evaluation and effectiveness of victim compensation schemes in India.
Good evening, everyone. I'm here before you all to discuss about the variability in the victim compensation schemes. The variability is there only because of one thing, that just like the Model Tenancy Act formulated by the Parliament recently, there should be a Victim Compensation Model Act also passed by the Parliament, so that variability should go. Once for all, it should go. So the variability is there because there is no regulatory framework as per Nipun Saxena. In Nipun Saxena, the Honorable Supreme Court held that there should be online platform, just like in Haryana, Mr. Sabharwal has said that there is an online portal. It is as per Nipun Saxena's case. It should be, the application should be decided in 60 days. That is not happening nowadays. That is the problem, that Nipun Saxena's judgment is not being given the weightage it had to be given. So I would like to say, firstly, the Parliament has to pass a regulatory framework or a law, then has to be replicated by the states therein. Then I would like to say that there was a Malimat committee in 2003, which was regarding the criminal justice system and which talked about the criminal justice system with a focus over the victim compensation. So the victim compensation, although I would like to say one thing, that Malimat committee was never implemented in India, which is a very sad part, I would say. The Malimat committee said one thing which was duly appreciated in the new BNS, that when the offender is not traced, when the offender is acquitted, then also the victim has to be compensated. BNS says the same in 396 subsection 3. That is fine. Malimat committee said that there has to be a central compensation fund. And this central compensation fund has to be from the money that the central government confiscates for the organized crimes. So I would like to quote here that recently I got to know about the Enforcement Directorate in India in 2024 itself, confiscating proceeds of crime to the tune of more than 30,000 CR in 24 itself, which is a huge amount. I would say that that 30,000 CR could be used to send the money back to the people who have been duped by the PMLA accused, but also when the money is unclaimed, then the money has to be given in the form of a central fund which can be used to give the victims the appropriate share, duly they deserve that. And Malimat committee also said that when the central fund is there, organized crime is there, or from the organized crime, the fund comes, when the fund will be given, then the victim will truly say that I have been duly given what I actually deserve. Victim is the least talked about person in the whole system when the whole system stands upon only the victim. The whole system stands on the victim. The victim, if he or she is satisfied with the system, then only this justice system will prevail for a longer period of time. So I would like to say one more thing, that in the case of Ankush Gaikwad versus State of Maharashtra by the Honorable Supreme Court, it has been held that interim compensation has to be given. And it is a very sad thing that the interim compensation in one of the cases, in the child abuse cases, that is a suo motu writ petition before the Supreme Court in 2019, the Supreme Court has the amicus curiae appointed who tells the data to the court that 99% of the victims in India never get the interim compensation, only 1% get. And of the total compensation given to all the victims, 99% of them never get the victim compensation. So I would like to say that the parliament has to take the lead and the states has to follow. Because in Nipun Saxena's case, when the 60 days period, which is given by the Honorable Supreme Court, that is binding article under Article 141 of the Constitution, still it is not being widely followed. It can be followed only when there is a Parliament Act. It can be followed when there is a state legislation for the same. So I would like to extend my gratitude to everybody for having me, for having kind patience, because this is my first public appearance, I would say. In my whole life, I was the kid who never appeared before anyone. So this is my first time. Sari pol chuk maaf. So thank you everyone.
You talked really well. Thank you, Mr. Sidhu, for highlighting the flaws in the victim compensation machinery. Now I would like to invite our final panelist in order to circle this victim compensation, our theme, which is victim compensation in criminal justice system. The person with the unparalleled legal acumen, Additional Advocate General, Punjab, Mr. Deepinder Singh, to provide his valuable insight on the very important topic, strengthening the institutional mechanism for effective victim compensation, role of the government and law enforcement.
First of all, my sincere thanks to the organizers for making me part of this program. Friends, Honorable Justice Gupta, Mr. Deol, Mr. Sabharwal and my younger friend, they have already given a picture in detail of this concept, victimology. It has been recent, earlier we used to deal with criminology, penology. Now this victimology concept has also come into being for last about 20 years. We have been discussing about central fund. Just for could gather information that central government has also created a fund, Central Victim Compensation Fund scheme in the year 2015 with a corpus of 200 crores per year. So the main aim of this central fund is to have a dialogue with the states and bring a uniformity in payment of compensation to all the victims. So that apart from that, central government is also having a Nirbhaya fund scheme in which a budgetary allocation is made on every budget. Then in Haryana, apart from Haryana Victim Compensation Scheme 2020, they have also sub-allocated a fund for Women Victim Compensation Fund separately after this Nirbhaya case. And in Punjab, we have Punjab Victim Compensation Scheme 2017. And to my knowledge, all the states in India have now formulated this victim compensation scheme. Earlier, till 2015 or 16, about 24 states had formulated. Then Supreme Court directed all the remaining states to come out with the scheme. And now all the states and 7 union territories have now come out with this scheme. Now, the purpose of victimology is to study the effect of crime on the victim, which my friends have already detailed. It is not a new concept. In earlier ancient India, there used to be panchayats, and there used to be, if we visit some forts and killas, there is, they say, insaf ka chabutra, insaf ki seat. They used to, that was not meant for punishing the accused. That was basically meant for compensating the victim. These, our village panchayats, our village, say, social systems, they used to produce the victim before that panchayat. Victim used to apologize. And it was not that simply his apology was accepted, but he was asked to compensate the victim in any form which was approved by the panchayat. Sometime it used to be a monetary compensation. Sometime even transfer of land was there. Sometime even transfer of certain properties was there to compensate the victim. I was just going through the case laws in 1984. One of our High Court, probably our Punjab and Haryana High Court, it reduced a offence of 302 into 304 Part 2 while awarding a compensation of 3 acres of lands to the victim in a murder case. But somehow Supreme Court did not agree with it. The observations of Supreme Court, that was a case in 1984. The observation Supreme Court was that if this is going to happen, that we give some victim and then reduce the sentence, then it will not good for criminal jurisprudence. But with passage of time, again the things have changed, and now this compensation scheme has come in all the states and also in all the union territories. And Supreme Court is pretty serious about the uniformity. One judgment was passed in another our state of Haryana matter, Suresh versus State of Haryana in 2015. Justice T.S. Thakur, Chief Justice. He after examining all the compensation schemes of the entire country, came to the conclusion that compensation in state of Kerala are highest. Compensation rates at that time in 2015-16 came to the conclusion that compensation rates in the state of Kerala are highest to the victims, and he directed all the state governments to follow the pattern until they come out with some improved or enhanced compensation. So the Honorable Supreme Court says that we are also of the view that there is need to consider upward revision in the scale for compensation, and pending such consideration to adopt the scale notified by state of Kerala in its scheme unless the scale awarded by any other state or UT is higher. At that time, state of Andhra Pradesh, Madhya Pradesh, Meghalaya, Telangana did not come out with the scheme, so they were directed to notify the scheme. Now, as far as the requirement of interim compensation is concerned, Honorable Supreme Court has again passed same observations in this judgment, same judgment, and the interim compensation which we have been discussing was given very importance by the Honorable Supreme Court. They clearly stated, we are of the view that it is the duty of the courts on taking cognizance of a criminal offence to ascertain whether there is tangible material to show commission of crime, whether the victim is identifiable, and whether victim of crime needs immediate financial relief. On being satisfied on an application or on its own motion, the court ought to direct grant of interim compensation subject to final compensation being determined later. Such duty continues at every stage of a criminal case where compensation ought to be given, has not been given, irrespective of the application by the victim. So the Honorable Supreme Court says that it is suo motu duty of the trial court also to come out with a compensation package. At the stage of final hearing, it is obligatory on the part of the court to advert to the provision and record a finding whether a case for grant of compensation has been made out, and if so, who is entitled to compensation and how much. So the Honorable Supreme Court has given due, even if there is no application from the victim, it is obligatory upon the trial court to come out with a first interim compensation order if required, and then also at the time of final hearing, it has, as per the language of the Supreme Court, it has been mandatory duty has been cast upon the honorable courts. Now we find in most of the judgments, even under section 302, that their courts are silent on this issue. They are although imposing fine to the extent of 5,000, 10,000, 50,000 or even 1 lakh under section 357 earlier CRPC. But in most of the judgments, as far as judgments under POCSO Acts are concerned, or other rape and other ladies offence are concerned, they are coming out with compensations judgments, but not under various other offences. So this victim compensation scheme, which is now presently in force in all the states in India, in my view is larger than the scope of section 357 and section 357A. And it creates a harmony between various aspects of legal jurisprudence. If it criminal provisions, it contains criminal provisions, civil remedies, rehabilitation support, even role of courts has come into picture, and then state accountability also. So all these 4 and 5 aspects are now a harmony and a part of this victim compensation scheme, and all the states and center, particularly my friends have been suggesting that some law should be there enacted by the parliament, have to take a call at all India level to be followed by all the states, so that there is a uniform pattern throughout the country. Now, this my friend was also referring to Ankush Shivaji Gaikwad case, that interim compensation has been made mandatory by the Honorable Supreme Court, that the courts trying a offence under criminal law should definitely grant interim compensation to the victim at the initial stage and then at the final stage. Now, in my view, still after even 20 to 30 years of this law, in 2009 this 2357A was enacted, and then various schemes have also come. But still, victim compensation scheme in India is at a very nascent stage. We have to move ahead. We have to move ahead, far ahead. If we have to, if we see, I was going through the books. If we see the law in England, it started in England in 1964. Then it started in USA in 1972. Then New Zealand has followed it, Australia has followed it, Canada has followed it, even Ireland has followed it. They are much, much, much ahead than India. So we have to take further many steps to reach at a level where we can, at the end of the day, say, yes, victims are being suitably compensated. Thank you very much.
Thank you. Due to the shortage of time, I have received the communication to conclude this discussion without the question answer session. So with the prior apology of the participant, I am concluding this discussion. So one thing is quite evident from the discussion, that victim compensation is not only a financial matter. It is a matter of justice, dignity, and rehabilitation. And I once again extend my gratitude to ILI chairperson of ILI and Honorable Chief Justice and Honorable Member of Bar Council of India, Mr. Suvir Sidhu. Thank you.